States Court of Appeals for the Fourth Circuit. Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable the United States Court of Appeals for the Fourth Circuit are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States and this honorable court.
Good morning, everybody. Take a seat, please. So is Judge Traxler on the phone?
Yes, sir.
Judge Traxler, is he able to communicate?
Should be.
Yes, I can hear you, Judge Agee.
All right. Well, good morning, Judge Traxler. We'll go ahead and
Good
commence.
morning.
Our first case is the United States versus Kim. Ms. Liguori.
Good morning. May it please the court. I'm Michelle Liguori from Ellison Winters for the appellant John Kim. There's no dispute between Mr. Kim and the government that Rwan versus United States changed the law in this circuit. Before Rwan, to convict a medical doctor under Section 841, the government was not required to prove that he knowingly or intentionally acted in an unauthorized manner. Mr. Kim entered his guilty pleas in December 2021, about 6 months before Rwan was decided. At the end of his first change of plea hearing, he raised the issue that was at the heart of Rwan. He told the court he had not acted willfully, and he said, "I'm not guilty." After consulting with his counsel, Mr. Kim did decide to plead guilty, but he pled guilty to the elements under the law at the time. He did not admit in his plea agreement or at the plea hearing that he knowingly or intentionally acted in an unauthorized manner.
Well, he said he read the indictment and he understood it and he was pleading guilty to it. And the indictment says, while acting and intending to act outside the usual course of professional practice and not for a legitimate medical purpose. What's wrong with that?
He did say that he read the indictment, but the district court told him the elements of the offense in a way that was inconsistent with the indictment. And so assuring that
But he was pleading guilty to the indictment. He said he read it, said he understood it. He said he was guilty. And the indictment appears to fully comply with Rwan.
Well, respectfully, I don't think the indictment does fully comply with Rwan. Rwan says that the knowingly and intentionally mens rea mental state applies to the act of distribution and also to.
But don't you think that the facts that was offered to support the plea of guilty pretty much satisfy every element required? It's hard to imagine a physician practicing medicine the way he did. I mean, they was fired from the hospital. He had 30 to 40 patients a day. He didn't examine some of them. He didn't do any kind of medical examination. He didn't have any medical devices in his house. Don't you think factually that would support the plea of guilty?
The evidence that the government set forth at the change of plea hearing would be objective evidence that the government could rely on for an inference.
I think it'd be overwhelming.
Well, the evidence in this case is not significantly different than the evidence in the Rwan case and the Khan case, where the 10th Circuit and the 11th Circuit concluded that if the jury didn't specifically find the intent required under Rwan, that those convictions had to be vacated. And so the question in this case would be what Mr. Kim's intent was. And to get relief in this appeal, our burden isn't to show that he likely would be acquitted at trial. The question is whether he would have put that issue to the jury at trial. And in the Khan case, the court did note the government pointed to voluminous trial testimony, it said, of circumstantial evidence of the defendant's intent. But the court in that case said that if the defendant disputed
But the instruction there was different than the instruction you have here. Isn't that correct?
In the Khan case, the instruction was different than the one here. In the Khan case, the court actually did instruct the jury in a way that would be consistent with Rwan. It put the knowingly and intentionally discussion before both distribution and the act of being unauthorized. But the court there gave a good faith instruction that would apply to both the conspiracy and to the substantive counts. And so the court reversed because it said that the jury heard the wrong mens rea requirement.
Well, maybe they did it accidentally, but each one of these counts says while acting and intending to act outside the usual course of professional practice and not for a legitimate medical purpose.
Well, it alleges that in the conjunctive. And typically when something's alleged in the conjunctive, it gives the government the option to prove one or the other. And here in the plea agreement and at the change of plea hearing, the government didn't proceed under an intending to act theory.
Well, under either standard, his practice of dispensing drugs to people that he didn't even examine, or dispensing drugs to people who told him that he was selling it to other people, is that in the course of regular practice?
I think that there's certainly an argument that that's not in the course of
I think
regular
Pretty
practice.
strong argument.
The
Yes, ma'am.
relevant inquiry would be, what was Mr. Kim, what did he know and what did he intend? And so he would have an opportunity to explain what his intent was, what he knew, what he thought he was doing when he engaged in the conduct that the government set forth at the change of plea hearing. And he did, it shows in the record that he disputed his intent. He raised that issue at his first change of plea hearing. And he also raised it at the sentencing hearing when he told the court he didn't intend to act unlawfully. And so the record here does create a reasonable probability that if Mr. Kim had known that the government had to prove beyond a reasonable doubt that he knew and intended to act in an unauthorized manner, that he would have put that issue to the jury. And there's other aspects of the record that show a reasonable probability that Mr. Kim would have made the decision to go to trial. So we talked about the contemporaneous evidence that his comments at the change of plea hearing, where he raised the very issue in Rouen. He raised the issue of his mental state, and that to him created questions in his mind about whether he was guilty. And he raised that same point again at the end of the sentencing hearing, bringing up the issue of his mental state. The timing of Mr. Kim's guilty plea in this case also suggests that he likely would have gone to trial if he had known that the government would have to prove beyond a reasonable doubt that he knew and intended to act outside the scope of practice. His guilty pleas were entered on the eve of trial. He was indicted in December 2018, and he maintained a guilty plea for almost 3 years. During that time, he retained counsel, and counsel got the case ready for trial. The parties twice filed proposed jury instructions in the case. The case was set for trial in February 2022, just weeks before he entered his guilty plea. And counsel disclosed a medical expert that would testify for the defense about pain treatment practices, and that would testify that several of the prescriptions at issue here were objectively within the bounds of professional practice. It's also not uncommon for doctors.
Based upon the presentation that he had, I mean, certainly the drugs were permissible to prescribe when the presentation supports that. He would have had an expert that would have said, you can go ahead and dispense medication without even seeing the patient.
I don't know that the expert, I don't know exactly what the record doesn't indicate exactly what the expert would have testified, but I believe that the expert would have testified that,
Well,
or there
if
was,
it's
it was
not in the
disclosed.
record, how can you represent what an expert would say?
It's not in the joint appendix, Your Honor, but there was filed in the district court an expert disclosure by the defense in the case. And it indicated that the expert would testify about several of the prescriptions at issue here, that they were within the bounds of professional practice. And I do,
Well,
my
they had
understanding
so
of,
many, I'm not sure several would make a difference.
well, the question will be, the expert would have testified that several were objectively within the bounds of professional practice. And the issue in this case would be what was Mr. Kim's intent with regard to all of, with regard to the counts that were charged. And I don't believe the government's proffer showed that Mr. Kim was regularly giving prescriptions without seeing patients. There was certainly one instance where the government set forth that he had given a prescription.
But he had
without
30 or
seeing
40
patients.
people there every day standing in line. In fact, there were so many people that the elementary school next door had to put a fence up.
That's on the record that there were
Right.
30 to 40 people, and that's not inconsistent with evidence in some of the other cases that the courts have reversed. So in the Rouen case, there were 100 people, 100 to 150 people visiting that clinic each day. And so facts similar to those here were not enough to make an error in instructing on the mens rea element, a harmless one. Mr. Kim also had personal characteristics that made it more likely that he would go to trial on these charges. Mr. Kim's a 76-year-old immigrant from South Korea. He went to medical school when he was almost 40 years old and became a doctor in his late 40s. At sentencing, counsel.
What does that have to do with whether or not he goes to trial?
I think Mr. Kim's personal characteristics, we have to ask, what would he have done? And counsel talked about
You
how.
have to offer something other than speculation about whether or not there's a likelihood they would go to trial.
I think we certainly have to offer more than speculation, but we have here Mr. Kim's comments at his change of plea hearing that he stopped the hearing because he wasn't sure if he was guilty of the offenses, and that he raised a specific issue that is at the heart of Ruan, the mental state. I think that shows that Mr. Kim may have made a different decision here if he had known about the elements of the offense. I think combined with him raising that issue again at sentencing shows that if he had known that the government had to prove that, he may have taken this case to trial. Counsel talked about Mr. Kim's strong sense of shame, which he said stemmed from his Korean culture, which made Mr. Kim very reluctant to enter a plea in this case. And the counsel talked about how he had several conversations with his children, which is what ultimately helped Mr. Kim decide to plead guilty. And so the record in this case overall paints a picture of someone who is very torn about pleading guilty. And that shows that if Mr. Kim had been informed of the mental state issue, which was something that was on his mind at the change of plea hearing, that he likely would have made a different decision here. And I wanted to address also the government's argument with regard to the conspiracy count. So the government's brief says that because Mr. Kim admitted, or because Mr. Kim pled guilty to the conspiracy count, that establishes the mens rea required under Ruan. And there's two problems with this argument. The first is that it's inconsistent with this court's decision in Hurwitz. Hurwitz held that an error in jury instructions on the mens rea for an 841 charge rendered a related conspiracy count invalid. Hurwitz involved a good faith instruction the defense asked for a good faith instruction and the court did not give it in that case. And the court held that even though the jury convicted on conspiracy, the failure to give a good faith instruction affected both the conspiracy count and the substantive counts, and it vacated all of them. And that discussion's in footnote 10 of the court's opinion in Hurwitz. The 10th Circuit reached the same conclusion in the Kahn case. It held that the failure to correctly advise on the mens rea affected both the substantive count and both the conspiracy count and the substantive counts. And these decisions make sense because to be guilty of a conspiracy, the defendant has to reach an agreement with the specific intent that the crime be committed.
Well, in this case, when you had several people that came in and purchased large amounts of drugs from him for distribution to other people, and he knew it, don't you think that's sufficient to support a conspiracy?
I think it depends on what his mental state is and what he specifically knew. And I think he didn't admit that. When the court told Mr. Kim what the government would have to prove for a conspiracy, it didn't say anything about an unlawful purpose or an intent to act unlawfully. And that makes this case different than
But I believe the supporting facts introduced by the prosecution indicated that he had distributed drugs to people knowing it was going to be redistributed to someone else with no presentation, no examination. You don't think that would support a conspiracy?
Well, the question is, did Mr. Kim admit to that or not? And he didn't. The record doesn't show that Mr. Kim admitted to knowing that to entering an agreement that he knew was unlawful.
Okay.
And that makes this case different than the cases that the government submitted in its supplemental authority, where the court did affirm a conspiracy conviction, because the court instructed the jury in those cases that to find the defendant guilty of conspiracy, it had to find that he agreed to an unlawful plan and that he agreed to further the plan's unlawful purpose. In this case, I'd like to address briefly the Farrell case from the Eastern District of Texas, which was a guilty plea case, and that it did involve a conspiracy count. It was a sole conspiracy count. And in that case, there actually was no Ruan error. The court instructed the defendant that to find him guilty of the conspiracy, it had to show that he knowingly and intentionally, or that he entered an agreement to knowingly and intentionally distribute in an unauthorized manner. So the court's discussion of this 841 underlying crime there was consistent with Ruan. And the court also did tell the defendant that to convict him, the government would have to show that he knew the unlawful purpose of the agreement and joined in it with the intent to further it. So the Farrell case is very different than this case. Also, Mr. Farrell pled guilty the day he was charged. And here Mr. Kim maintained his plea of not guilty for 3 years. And we would contend, because the record in this case does show a reasonable probability that if Mr. Kim had been advised of the mens rea requirement under Ruan, that he would have made a different decision and would have decided to put the charges in this case to a jury. And so we're asking the court to vacate his convictions.
All right.
Thank
Thank you
you.
very much. You've got some rebuttal time. Mr. Casper, we'll hear from you.
May it please the court, Andrew Casper on behalf of the United States. I'm going to focus on the Ruan issue. I'm happy to answer any questions about the allocution issue if the court has them. So the government has put forth 3 bases on which the court may affirm the convictions, the conspiracy to unlawfully distribute controlled substances convictions, as well as the substantive offenses.
Can you move a little closer to the mic? It's hard to hear.
I apologize. Is that better? So the first basis is that defendant was properly advised of the mens rea requirement recognized by the Supreme Court in Ruan. As the court is aware, Ruan said that the knowing or an intentional mens rea requirement applies to both the action of dispensing and to the act of dispensing outside the scope of the usual course of medical practice or not for a legitimate medical purpose. Here, as the court has already noted, the second superseding indictment as to the substantive offenses charged the defendant while acting and intending to act outside the usual course of professional practice and not for a legitimate medical purpose to dispense these controlled substances. The United States argues that that is consistent with what Ruan asked. The court made sure that defendant read and understood the indictment, and the defendant said he did. That's at JA 62. It's also really important to note that when the court accepted the defendant's guilty plea, the court asked the defendant, "Are you pleading guilty to the specified counts of the second superseding indictment?" So he pled guilty to the language that I just read of while acting and intending to act. Additionally, defendant's plea agreement expressly said that he was pleading guilty to the specified offenses in the second superseding indictment. So again, he is pleading guilty to acting and intending to act outside the usual course of medical practice, entirely consistent with Ruan. Additionally, the court's instruction as to this oral instruction as to defendant as to what the offense was that the government must bear the burden of showing beyond a reasonable doubt that you prescribed, dispensed, or distributed oxycodone. You acted knowingly and intentionally, and you did that outside the usual course of professional practice and other than for a legitimate medical purpose. I think it's really useful to compare that statement where that refers directly to the preceding phrase, "You acted knowingly, intentionally."
Which page of the appendix are you reading from?
That's on JA 73, Your Honor. I think it's useful to compare that with Ruan. So on page 1297, the court states, the district court enumerated the elements of a section 841A charge. The defendant dispensed the controlled substance. Defendant did so knowingly and intentionally, and the defendant did not have authorization. Grammatically, the quote "did so" phrase links the mens rea element to the preceding element describing the actus reus of dispensing the controlled substance, but not the except as authorized exception. That's precisely the opposite of what happened in our case, where the "you did that" language links the usual course of medical professional practice element with acted knowingly and intelligently. Additionally, there's no indication in this case that there was any shifting of the burden to the government. There's been some suggestion of that in the defendant's brief. The court repeatedly advised defendant that the burden lied with the government, never suggested it lied anywhere else. In JA 63, for example, says, and at the trial, there would be no burden on you. The burden rests on the shoulders of the government to prove you guilty beyond a reasonable doubt. So we would say that that all complied exactly what Ruan intended. The second basis for which this court can affirm defendant's guilty plea is his plea to the conspiracy charge. This court has held in the McFadden case, which is 823 F3rd 217 at page 224, that the omission of an essential element from a jury instruction is harmless, quote, when the omitted element overlaps with an element in another count of conviction. Here, and just to make clear, Your Honors, this is a plain error case. To the extent there is any error, and the government is not conceding that there is error, but to the extent that there is error, it would be a plain error case because the defendant did not object at trial. Here, the court
He did not object at trial to what exactly?
he did not object to the make a Ruan objection, saying that he should have been advised as to what the knowledge requirement applied to in terms of the elements of the offense. At pages, this is in the plea agreement at page 197 to 198 of the JA, defendant pleaded guilty to, quote, forming an agreement to prescribe a quantity of oxycodone outside the usual course of professional practice and not for a legitimate medical purpose, and that defendant knew the purpose of this agreement or conspiracy. To the extent that there's an argument that conspiracy does not require a specific intent as to the underlying offense, I would direct the court to this court's decision in United States versus Vinson, which is at 852 F3rd 333. The elements of conspiracy are that two or more persons agreed to commit a substantive offense, and that at some time during the conspiracy, the defendant had knowledge of the criminal objective of the agreement and willfully joined the conspiracy with the intent to further its unlawful purpose. Here, the court used almost identical language. This is at JA page 73. You formed an agreement to distribute, prescribe, and dispense and possess with an intent to distribute oxycodone, hydrocodone, and methadone as charged. And again, the charging document refers to acting and intending to act. And you knew the purpose of this agreement or conspiracy, and that you knowingly and willfully participated in or became a part of it. So again, the conspiracy count specifically complies with the Ruan requirements, and because he pled guilty to the conspiracy charge, he had the requisite intent for the other charges. I would further note that all of these substantive offenses are within the temporal scope of the alleged conspiracy, and defendant has never argued that any particular substantive offense is not outside scope of the conspiracy. I would refer to this court on whether the conspiracy plea sort of rectifies any error, and again, the government concedes no error as to the advising on substantive offenses. The court's decision in Ajayi, which is from the Fifth Circuit, we find that even if idiosyncratic portions of the jury charge lacked clarity on Section 841A's mens rea requirement, the adequate Section 846 mens rea instruction filled in any gap by clearly requiring that the jury find that the defendant have understood the illegitimate nature of his conduct. And in the Ruan remand decision, consistent with the government's argument here, held that the conspiracy conviction was valid, even though that the substantive offenses were invalid because of the good faith instruction offered there. And then finally, and this is the third basis to affirm the conspiracy and substantive offenses, overwhelming evidence established defendant's guilt, including that they had the requisite mens rea. And so there's no prejudice to defendant's substantial rights if there was an error. And so here, the standard for plain error is a reasonable probability that but for the error, defendant would have not entered a guilty plea. This is a, quote, difficult to meet standard, that's the Supreme Court said in Puckett. Look at the entire record, so that includes the PSR as well as the government's proffer of evidence, statement of facts at trial or at the plea hearing. And it's also really important to emphasize that the government can prove the knowledge requirement through circumstantial evidence. It does not have to have a statement from the defendant that I was acting outside the course of legitimate medical practice. the court, Ruan says the scope of the doctor's prescribing authority remains, quote, tethered to objective criteria such as legitimate medical purpose and usual course of professional practice. So the, quote, more unreasonable a defendant's asserted beliefs or misunderstandings are, especially as measured against objective criteria, the more likely the jury will find that the government has carried its burden. Here, as Judge Hudson has already noted, there's a wealth of evidence as to substantive counts as well as the conspiracy. The defendant acted outside the scope of any sort of legitimate medical practice. And that sort of extreme disregard of standard medical practice is probative of his intent. So we know, for example, the defendant was previously employed by a hospital. He was counseled by his employer about engaging in improper prescribing a practice related to controlled substances, opioids in particular, and he resigned. He then started his own practice originally out of his house. His receptionist and practice operator, his co-conspirator in this case, Ms. Thompson, had no medical training, but was performing medical exams like taking blood pressure and vital signs. He would occasionally drug test patients, but they were not accurately recorded, and he dispensed prescriptions to patients who tested positive for controlled substances. He also told somebody who worked in his office that it didn't matter where they file and whose file they put the results of these drug tests. His patients frequently smelled of marijuana. He prescribed opioids in combination with benzodiazepine drugs, particularly alprazolam, which is a known combination of abuse. It's used by drug abusers to enhance the high. He had minimal medical equipment and did minimal medical examinations. All the transactions were in cash. There were 2 patient overdoses that were within days of receiving prescriptions from the defendant. And then as to particular days, the defendant, the confidential informant, went into the office, obtained prescriptions from the defendant for opioids and other controlled substances after minimal examination. On certain days, he also purchased marijuana. In one case, he purchased it from defendant's co-conspirator, and then he gave the cash. And this is all reported by the government to defendant for the marijuana purchase. Again, a reasonable person, or doctor acting in the course of his legitimate medical practice would not, sell marijuana at the same time as he is prescribing a controlled substance. He also offered to the confidential informant to write prescriptions for opioids in exchange for as the interest on a loan. That would be his interest on the loan. He had customers perform work on his behalf in exchange for prescriptions. These are all conduct that is indicative that he had the lack of the requisite intent to prescribe properly. He intended to prescribe.
Am I also correct that he kept no medical records on any of his patients?
My understanding, Your Honor, is that there were some records, but they were not extensive. And the issue, the reason why the hospital counseled him and he led to his resignation is he was not keeping proper medical records as to his prescribing.
And was that appears from what I've seen also true of his own private practice?
Yes, and as I just mentioned, Your Honor, to the extent he had the drug testing, for example, he wasn't even filing it in the proper patient's files. He also issued a prescription for oxycodone for a patient who he didn't visit. It was the alleged father of a patient, and he went ahead and issued the prescription for that patient without seeing him. He issued a prescription for oxycodone to a patient who asked for an increase in his prescription so he could sell more pills on the street. So these are all indicative of not prescribing properly and intending not to prescribe properly. I'd also like to distinguish the Ruan and Khan cases on remand. I think a really important point of distinction between those cases and our cases is that those were jury trial cases where there was an instruction by the court as to good faith. In each of those cases, the good faith instruction said that if the defendant, if there's an absence of objective good faith, then the defendant could be held guilty. And the Supreme Court in the Ruan case said that objective good faith instruction was problematic. And that objective good faith instruction in the Khan case in the 10th Circuit tainted all, and there's actually 2 issues with Khan, but tainted all the convictions. And that was the basis why the court struck the convictions on remand. We have no good faith from what I can tell in this record, in terms of what he was advised as to the elements of the offense, as to what he was pleading guilty, good faith does not appear in it. It's only the affirmative duty of the government to show his knowledge and the two acts that are required. So that's one point of distinction. It's very important. A second, in the Ruan case, as I said earlier, the language the court used indicated that the knowledge requirement only modified the act of dispensing. That is different from what was used here by both in the indictment and what the court said. Third, as to the Khan case, another key point of distinction is that the 10th Circuit had a different pre-existing interpretation of the applicable regulation, where the usual course of professional practice was in the disjunctive with the not a legitimate medical purpose, and the usual course of professional practice was an independent basis to convict, and that was a purely objective standard, and that applied to both the conspiracy counts and to the substantive offenses. And so the conspiracy's object could have been an objective standard. That's not the case here again, because we've alleged in the indictment a subjective standard, and that was what he pled guilty to. Finally, as to whether there's a reasonable probability that defendant would have not pled guilty, first, his during this initial plea hearing when they did not move forward that day, the record indicates that he was feeling cultural shame. Not that he didn't know he was guilty, but he was cultural shame, was not ready to plead guilty. That's inconsistent with. That's not inconsistent with him actually knowing that he was guilty, which is what he said on the record to the court when he was asked. The other thing, another important point is, even to this day, he has never said that he will go to trial if he was properly instructed as to the knowledge requirement. In this court's decision in Massenburg, which is 564 F3rd 337 at page 343, this court declined to notice plain error when the defendant never alleged on appeal that he would have gone to trial in the absence of the error, which is what I understand to be the case here. Third, and this is a really important point, there was a substantial benefit that accrued to him from pleading guilty. There was 34 counts in the indictment. The government dismissed 26 of those counts. And most importantly, the government agreed to stipulate that only the drug weight for the conviction counts could be used in calculating his sentence. That stipulation materially reduced the term he would have faced, because as you all know, drug weight is a decisive factor in determining a sentence under the guidelines. So he received a substantial benefit from this sentence. If the court has no further questions, I would just say we ask the court to affirm the conviction sentence.
Judge Traxler, do you have any questions?
No, I do not. Thank you, Judge Agee.
Thank you, Mr. Casper. Ms. LaGroy, you've got some rebuttal time.
To address a few of the points that the government made here, when Mr. Kim entered his guilty pleas, he pled guilty to the essential elements of the counts that were subject to his plea. He did not plead guilty to every allegation that was made in the indictment. And the elements that he was pleading guilty to are those that are set forth in his plea agreement. And the plea agreement does not include, as one of the elements of the offense, that he had a knowing and an intentional mens rea with regard to acting without authorization. And the district court, when it told him the elements of the offense, did not include a mens rea for the lack of authorization. And this court treats the lack of authorization as an essential element of a Section 841 charge against a medical doctor. That's clear from this court's opinion in Hurwitz in footnote 7. And under Hayward, it's error for a district court not to advise the defendant of the mens rea element that applies to an essential element.
Let's focus on the facts that supported the plea of guilty. I assume the prosecutor either presented it in writing, as you do here in the Eastern District of Virginia, or orally recited it on the record. Did the defendant object at all to the prosecution's discussion and detailing of the facts? I mean, he was confronted with it at that time. Did he speak up and say, no, Your Honor, that element of the government statement of facts is not true?
The defendant, at the end of the first change of plea hearing after the government had gone through the facts, he stopped the hearing and said, I'm not guilty. I didn't do this.
That was
willfully."
initially.
That was initially. He didn't raise specific objections during the factual recitation at a second change of plea hearing.
So when the court accepted his plea of guilty and the government introduced the statement of facts, he offered no objection.
That's correct. He didn't
Okay.
object to the facts
Yes,
stated.
ma'am.
But the facts today are no different than the facts were. They're no more overwhelming than the facts were at his first change of plea hearing, where he stopped the hearing and he said, I didn't do this willfully, and he wasn't sure if he was guilty or not. And so the standard here is not to
But he
show,
had no doubt the second time.
well, he hadn't been instructed that the government would have to prove his intent with regard to acting without authorization.
Okay.
And with regard to the way that the district court set out the elements in this case, it's the same. The district court explained the elements of the Section 841 charge in the same way that the district court did in the Ruan case. And in the remand decision, that the 11th Circuit held that that was inconsistent with the Supreme Court's decision in Ruan, because the district court there didn't apply the mens rea element to the acting without authorization.
So you disagree with the government's reading of the court's instruction, page 73?
Yes, I disagree that that applies the mens rea to acting without authorization. And one point with regard to how the court discussed the elements, the government talks about the court's instruction on count 4, which is on page 73, but the court actually uses slightly different language when it goes through counts 4, 8, 11, and 14. It doesn't have the that, which the government relies on heavily. It uses slightly different language, but every time it says knowing and intentional after the distribution and does not apply that to the acting without authorization. And that's the same way that the court set out the elements in the Ruan case, which the 11th Circuit held on remand, was inconsistent with Ruan. And the government doesn't dispute that there's a change in the law. And under the 4th Circuit's cases before Ruan, in particular in the Hurwitz case, you can see it, the court lays out the elements there. It doesn't apply the mens rea to the acting without authorization element. And the court's instructions here were consistent with the law at the time, and they were inconsistent with the law now after Ruan.
Okay, anything else?
No, Your Honors, if the court has no further questions, we'd ask the court to vacate the Mr. Kim's convictions, because there's a reasonable probability he would have gone to trial if he had not been informed. And if I may, Your Honor, I do just want to represent, it's my understanding that Mr. Kim would take this case to trial if the court vacated his convictions based on the Ruan error. Thank you.
All right. We'll come down and Greek council and then take a very short recess.
This honorable court will take a brief recess.
Please be seated. Our next case is Coleman versus Kendall. Mr. Brooker. Are you going to introduce our counsel today? All right.
John Harris, right here at Thrill at UNC School of Law, and we have Alexander Voss.
All right. So according to my sheet, Ms. Lawson, you're going to do the opening argument. And Mr. Harris, the rebuttal. All right. Ms. Lawson, hear from you.
Thank you. Good morning, Your Honors. As I said, I'm Alex Lawson from the UNC Clinic, counsel for Appellant Blair Coleman. So we're here today because combat veteran Sergeant Coleman has been denied his proper retirement disability rating due to the PDBR's misapplication of the law, arbitrary and capricious rating decision that was improperly upheld by the district court when they granted summary judgment. Now, Sergeant Coleman is a combat veteran who served honorably in Iraq. He witnessed some of the horrors of war, including a deadly rocket attack where a fellow airman was dismembered. This traumatic event led Sergeant Coleman to experience nightmares, intrusive memories, and panic attacks.
I know you didn't brief this here, but you did talk about it quite a bit in the trial below. I think we have to make an assessment initially as to jurisdiction. Why don't you speak a bit on jurisdiction and why it is that this is not a matter that should be before the Court of Federal Claims?
Yes, Your Honor. I can speak only briefly to this. We're not prepared to argue this in greater depth simply because we agree with the lower court's finding that Sergeant Coleman is seeking retirement status and not necessarily retirement pay. So this court does have jurisdiction under the APA.
So, well, I understand your agreement, but jurisdiction doesn't matter. We have to independently determine that. You agreed on some facts there, which we may or may not agree with, but certainly something to be said here as to whether we do have jurisdiction. There are a lot of cases on this out there. But if you want to proceed, I mean, proceed. But I think that ought to be at least presented first as to whether we even have jurisdiction over this, because it looks like you easily could say the Tucker Act, this is something that should go there because there's some indicia of money damages here, notwithstanding the retirement waiver he's made.
Sure. Again, I'll just say briefly.
And that's my understanding. He has waived retirement pay.
That is correct. Yeah, Sergeant Coleman has waived retirement pay. So at this time, we're only seeking retirement status and the non-monetary benefits associated with that status.
All right.
So we're here because we are challenging the PDBR's determination that Sergeant Coleman has a 10% rating after the end of his time on the TDRL. Now, the PDBR is a court that is a board that Congress created specifically to address a systematic unfairness of the system where service members and veterans like Sergeant Coleman were being denied their retirement status and given unfairly low disability ratings. The PDBR's mandate was to review these ratings and where warranted, adjust them upwards. Now, the PDBR
So in the interest of conserving your time, why don't you go right directly and tell us what you say they did wrong?
Yes, Your Honor. So the PDBR misapplied the law in this case. They did not properly apply 4.129 in its 38 CFR 4.129 in its entirety, as well as ignored 10 U.S.C. 1210, the law that governs the TDRL. Now, both of these laws require a physical examination in order to make a determination of disability, in order to make in order to warrant any change in disability determination. So the PDBR first decided that 4.129 does apply to Mr. Coleman's case, and they did properly first place him on the TDRL and set him at 50% for a temporary.
I recognize that. Looks to me procedurally, he filed an opening brief here, and then looks like you students that wrote the reply brief sort of backed away something. It looks like to me he pretty much conceded that he got that physical exam in February, I think of 2006, that he said complied with this 4.29. How do we not take that as a concession?
Yes, Your Honor. So it is a bit of a complex issue. And while we agree that the VA exam could serve as a functional equivalent if, if you are so inclined, however, we disagree that the VA exam can serve as the legal requirement under 4.129. And the reason it cannot serve as the legal requirement under 4.129 is that.
So you're claiming there should have been a later exam, even though the time in question goes back. It goes back in time, which seems to create something of an impossibility or an absurdity to have an exam now that's to establish a condition in the past.
Yes.
In fact, years in the past.
Yes, correct. Let me clarify that we are not arguing that we want a sort of a modern or a new exam in order to make a determination of disability back in time. We're talking about a retroactive application. And under 1210 and 4.129, a re-examination at the appropriate time is what is necessary.
I thought those examinations were permissible, but that they were not mandatory. You say that the statute or regulation has a mandatory physical examination requirement?
In order to warrant a change in disability rating, yes, we argue that a physical examination is required. And the reason we argue that is, it's explicit under 1210. If you're looking at 1210A, a physical examination is necessary in order to determine both a service member or veteran's sort of stability as well as their level of disability after their time on the TDRL. But we also believe 4.129, plain reading of 4.129 explicitly states that a physical exam is a condition precedent in order to warrant a change in disability determination. So in order to make a change in disability, you must have a physical exam to justify that change. Now, to answer your question about sort of doesn't this create an impossibility, because we're not asking for a new exam and, we understand that the PDBR can't go back in time and establish some new exam. But just that this exam going back in time is not possible doesn't prevent the proper application of the law. You can apply 4.129 to the extent feasible solely by placing Mr. Coleman on the TDRL and increasing his rating to 50%. It is his subsequent reduction from 50% that needs to be justified. And there was no justification here because there was no physical exam and that reduction was thus arbitrary and capricious. To continue, I want to address why the VA exam that happened in February cannot be used as a physical exam to satisfy 4.129. It is explicit in the language of 4.129 that the exam must be conducted by the rating agency. And I'd like to mention that we're talking about the old legacy system that was in place at the time in 2005 and 2006. And at the time, the DOD and the separate branches had sole authority. They did not have to agree with the VA, but they were using the VA regulations and guidance similarly to make those similar disability determinations. Now, when the DOD, took that authority in order to make the disability determinations, that goes along with the responsibility to conduct the legally required exams. So in this case, the government did not conduct an exam that was required by the legacy system at that time. And thus they cannot reduce Mr. Coleman's rating. I also want to mention that the government argues that the PDBR records review could substitute as the exam. We vehemently disagree with that, especially because we're talking about medical determinations of disability. I think a common sense reading is this exam needs to be a medical assessment of Mr. Coleman's person and not of his record. When we're talking about the other two exams that are available, there is also some medical evidence from the IPEB and the initial NARSM and exams that were conducted that determined Mr. Coleman had an unstable mental health condition. So while that evidence can be looked at by the board, because that evidence was generated prior to Mr. Coleman's placement on the TDRL, that can't be used to then justify and understand what his condition was at the end of his time on the TDRL. Now that's in accordance with 1210 as well, that says a physical assessment has happened after his placement on the TDRL. Now, the only other exam that we have available on the record is the VA exam. Now, again, I said that the VA exam was not done by the rating agency. But if the VA exam were to count, that's the only exam that the PDBR could use to justify its decision. And that VA exam explicitly rated Mr. Coleman at a 30% rating. So the PDBR even said that a 30%, looking at the VA exam, could say that 30% could be surmised. So the VA not only looked at this evidence a little bit incorrectly, but they also did not use the VA exam to properly justify their reduction of his rating. Now, this is also all in accordance with sort of the purpose of the PDBR. I know the government argued that this sort of outcome might be sort of unusual and against the purpose of the PDBR under 1554A. However, again, the PDBR was created as a board of equity, of fairness, of looking at these ratings and determining whether or not they should only be adjusted upwards. And in this case, the critical determination that 4.129 even applies to Mr. Coleman's case was the critical determination that satisfied the purpose of the PDBR. Not to mention they did change his rating to up to 50%, again, well within the purpose of the PDBR. These sort of systematic low ratings for the veterans were unfair. And so the PDBR satisfied the purpose with its decision. In addition, I want to briefly mention that in the PDBR's report, the PDBR explicitly stated that 30% could be surmised looking at the evidence in front of it, namely the VA C&P exam. Now, when there is a question of
30% indicated he was experiencing symptoms. Doesn't it require more than that? It was actually caused the occupational decrease.
I'm sorry.
In other words, the 30% that you allude to indicates that he was experiencing those symptoms. But it seems that the symptoms must also cause an occupational decrease in the work efficiency and intermittent periods of the ability to perform the occupational tasks. So is there not a difference between experiencing and causing it? When you're talking about the 30% rating.
Sure. So to my understanding, when you are looking at sort of 4.130, the main disability rating regulation, the ratings are not just about symptoms, they are also about a level of social and occupational impairment. Now, Mr. Coleman, he sought out VA care himself. He was not required to do so, and he did that because he needed the support at the time. So I think it's clear to say he was experiencing these symptoms, but the rating itself does talk about social and occupational functioning, not to mention that the PDBR's report referencing the VA exam said that the 30% is due to social and occupational functioning. The sentence itself links the functioning to the 30%, not just the symptoms. So we're looking at a kind of a holistic approach. So, in this case, Sergeant Coleman was both sort of legally unstable. He had a qualifying mental health condition that, required application of 4.129, and he was experiencing symptoms of a downward decline. Right? He was at 0% coming into the Air Force, ended up at 10% in October 2005, and then his downward decline was then supported by the VA decision.
All right. Have you got anything else for us?
No, Your Honor. Thank you for your time.
All right. Thank you very much. We'll hear from Mr. Harris on rebuttal. Ms. McLean.
Thank you. Good morning, Your Honor. Caroline McLean from the United States. May it please the court.
Why don't you start with Judge Wynn's question about jurisdiction?
Sure. Thank you, Your Honor. We preserved at the district court level the objection to the magistrate judge's recommendation that the court lacks subject matter jurisdiction, that Mr. Coleman should have brought his claim under the Tucker Act. We acknowledge that once.
But you didn't brief it.
We did not at the appellate court level, because we did at the district court level concede that once Mr. Coleman waived military retirement pay when we were last at this court, that under Kidwell, the DC Circuit decision, that it has a more plaintiff-friendly approach to whether or not a plaintiff is asking for equitable or just a monetary relief, that it was a tougher decision, a tougher question. So that we did not brief it at this court, focusing instead.
Whether or not you briefed it, we still have to establish a jurisdiction at every stage.
Correct, Your Honor. The government maintains that because the statute providing for Mr. Coleman's retirement, 1201, was money mandating, despite his waiver, he was not able to waive himself out of asking essentially for monetary relief.
So there's a court of claims decision, the Smith case, that goes the other way on this, Smith versus United States case. And then below, you argued that the Kidwell standard was the wrong one. So are you changing your mind here? So Kidwell is okay?
I'll be honest, I'm not familiar with the Smith case you're referencing. Can you remind me of the holding?
You can check it out later. I just
Okay.
suffice it to say there's a court of claims case that goes directly against this. That indicates that jurisdiction is a problem. It's a court of claims case, but that's where it would go if in fact we didn't have jurisdiction. But you did argue below that the Kidwell standard was the wrong one. So I'm just asking, you now say it is the right standard that we apply?
No, I don't think it's the right standard to apply. We merely acknowledge at the district court level that under Kidwell, once Mr. Coleman waived his monetary relief, it was a tougher question, but we do not believe that Kidwell is the correct standard to apply in the circuit. Moving on toward to the board's decision, the board acted reasonably. There was nothing arbitrary or capricious about its decision-making or the ultimate decision that it reached. The board did exactly what it was supposed to do here, which was review the informal physical evaluation board that Mr. Coleman received at the time of his original separation. And to do that, the Department of Defense required the board to do three things. Required the board to not only review that original decision, but the entire case record underlying it. It also required—
Counsel seems to argue that there's an additional physical examination requirement that did not occur at the proper time, and therefore everything after that essentially is void. I don't know if that's your understanding of the argument or not, but that's what I took from it.
My understanding of the argument was that when the board applied section BASRA 4.129, so when it retroactively changed Mr. Coleman's disability rating for a retroactive period of 6 months, subject to a subsequent examination, that my colleagues are arguing that examination had to be a physical examination. But as they also acknowledged, and as the court has acknowledged, that would be impossible. And additionally, the regulation does not require a physical examination. It requires an examination. So that examination occurred in the form of a retroactive records review, which was, of course, all the board as a board of review could do in the situation.
What other type of examination would it be?
The examination that occurred, Your Honor, a record review of an examination. 1554A, statute that creates board, when Congress created it, said that it is to examine and evaluate the original medical evaluation board. To do that, it is to look at the record, and then the Department of Defense, in implementing the statutory intent, issued regulations that say this is what the board is supposed to do. It's supposed to look at that evaluation and the case record underlying it.
So what does it mean when you add schedule and evaluate the examination? I got you. You just say conducting an examination, but this is schedule and an examination in the context of the military, where this type of rating is, I guess, when you get out, you initially get this rating. And it seems to me, of course, I didn't even know this, having been a military guy myself, that each service seems to have different requirements in terms of the rating. So the Air Force has a particular one to follow, but it seems at least in 4.129, this language of schedule and examination is hard for me not to phantom that had to be a physical examination. But do you need that? Do we need to make that determination as to whether that language includes or means physical examination?
I don't think so, Your Honor, because an examination was arguably scheduled in this case at the end of the retroactive period on the of the VASRID.
Is that the February 2006 examination you're talking about?
I'm not. I'm talking about the board's examination of the records, which ended on the amended date of his separation at the end of that retroactive 6-month period. It included in its examination evidence from that February 2006 examination, but we are not contending that is a physical examination, that the board could somehow have, required a physical examination. The examination occurred. It was a records examination.
So in this circumstance, you're using essentially review as the equivalent of examination statute or regulation.
We are, Your Honor, and that's what Congress called the Board of Review when it created it, a Board of Review. And that's the examination that took place. The board applied the VASRID correctly in the way that it could, because it, of course, could not go back in time. And the second thing the board did was what it was also required to do, which was to compare Mr. Coleman's original physical evaluation board rating with the subsequent rating of the VA in February in 2006, and consider the variance between the two in arriving at its ultimate recommendation. And it did this. The board's record of proceedings carefully lays out the evidence from the original separation and that medical evaluation, and then also evidence from the subsequent VA examination. The board literally cites portions of that examination. The board then explained exactly what it was doing. It said at the end of the retroactive 6-month period, all board members unanimously agreed that a 50% rating was not met. So the question the board grappled with was whether a 10% or a 30% rating applied. And it acknowledged, as my colleague mentioned, that there was evidence in the VA rating to support a 30% recommendation. I think actually its acknowledgement of that shows the honest journey the board was taking. However, it also cited evidence from both the original separation examination and the VA examination 6 months later that supported its ultimate conclusion of a 10% rating. Some of that evidence that is laid out in the board's record includes evidence from the mental status examination the VA conducted in February 2006. I'll mention some of it here. So Mr. Coleman was then experiencing some startle reaction, minimal isolation, occasional nightmares and intrusive memories, though the intrusive memories were both good and bad, and they were getting better. His memory and concentration was okay. His energy level was fairly good. He denied significant problems with depression. He described himself as fairly anxious, but the examiner noted his attitude was alert and oriented. He was neatly groomed and dressed. He was behaving normally. His cognitive memory was within normal limits and his judgment was good. He denied homicidal or suicidal ideations, flashback, or depression. These are pieces of evidence that the board explicitly referenced in its discussion. And the question before the district court, under the appropriate standard of review, which the district court correctly applied, was whether or not there was a rational connection between the facts that the board found and it observed and the ultimate choice it made. And there was, and the district court correctly determined that the board's decision should be sustained for that reason. The board acted reasonably when it did not. The district court correctly found that the board acted reasonably when it did not order a physical reexamination, because that examination would not have been relevant to the board's inquiry of the original of Mr. Coleman's status at separation, his ability to perform the occupation at the time the board was needed to make its decision. The district court also was correct.
Let me ask you that Congress only said a record-based examination. To what extent do we look at what DOD and reports with 4.129 and this temporary disability retirement list that it then brings in? Don't we have to consider those requirements too?
Yes, Your Honor, you do. And in the DOD, in requiring the board to implement 4.129 was also acting consistently with what Congress required. In 2008, not only did Congress create the Board of Review, but it also, in the National Defense Authorization Act, required the military to apply 4.129. So the DOD, in requiring the board to apply 4.129, was acting consistently with what Congress was mandating the military to do. This was, of course, in the form of a retroactive records review, but it was consistent with congressional intent. the district court was correct to decide summary judgment here on the administrative record. This was, I think, Mr. Coleman's second point in his appeal, because summary judgment is the appropriate vehicle for district courts to decide questions or agency review actions under the Administrative Procedures Act. This court has held that a party challenging an agency action bears a special burden for demonstrating that the court should reach beyond the record to examine things that should have been for the agency and weren't. We would argue that Mr. Coleman has not met his burden here to support a remand to the district court for the creation of post hoc evidence that many years later would have no bearing on the decision the Board of Review made and the decision it was reviewing at the original time of its separation. If there are no more questions from the panel.
No questions.
All right, thank you very much. Mr. Harris, you have some rebuttal time.
Thank you, Your Honor. Good morning. My name is Will Harris, and I'm counsel for appellant Blair Coleman. So I'd like to first discuss a few points raised by the court, and then discuss a few of our own points, if time permits. So first of all, Your Honor, the impossibility of the exam has been brought up several times, and we'd like to address that again. When you read the statutes and regulations all together, the impossibility of the exam does not present a problem, and the law can be followed. The PDBR can fulfill its purpose given the impossibility of the exam. That is because based on 10 USC 1210, 1210A and 1210B provide two different ways off of the TDR. 1210A requires physical examination, and 1210B says that if for whatever reason an exam is not done, then after 5 years the disability must be considered permanent, and that is the service member's disability rating from that point on. And this shows that Congress contemplated a situation in which, for whatever reason, an exam is not given. It's just wanted to address that outright, because the impossibility of the exam makes it a little bit difficult to see that there's a clear legislative and regulatory path that makes sense and that follows all the regulations. Another issue I'd like to bring up that my co-counsel briefly mentioned but didn't get to quite fully explain is 4.3 and 4.7 of the Bastard D. 4.3 is the reasonable doubt provision, and it says essentially that when
the government says those arguments are waived.
Your Honor, we respectfully disagree.
I thought you would, but tell us why.
Well, Your Honor, first of all, it's not a question of issue preclusion. Our argument from the very beginning has been that the government was arbitrary and capricious because they did not follow the Bastard D properly. 4.3 and 4.7 are seminal parts of the Bastard D. They're interpretive canons.
Did you argue those to the district court?
We did not argue them specifically, Your Honor. We recognize that. However, the PDBR report itself mentions 4.3. And so we think that even if Your Honors believe that that issue has been precluded, there are various exceptions to the issue preclusion rule. And we think that under basically all these exceptions, this court should consider those arguments because the government was aware of 4.3 as evidenced by it showing up in the PDBR report. And frankly, it's just a very
right. But if you didn't argue that to the district court, then neither the government or the court was on notice that you thought that was a legal argument.
Well, Your Honor, again, I'd just like to say our argument from the very beginning has been that the government did not follow the Bastard D, and we acknowledge that we did not specifically mention 4.3 and 4.7. However, we think that the fact that we did not go into detailed enough briefing shouldn't preclude Mr. Coleman from receiving the remedy that he's entitled to in this case. I'd like to move on, Your Honor, to a question brought up by Your Honors regarding whether the exam must be a physical exam. We think that, again, when you read these statutes and regulations together, the only logical outcome is that a physical exam is required. As you mentioned, Judge Wynn, 4.129 requires that the rating agency, which in this case is the Air Force, must schedule an examination. We think that the only plain reading of that regulation is that a physical examination is contemplated. Again, under 4.129, the physical examination is required to determine whether a change in disability rating is warranted. The government properly applied 4.129. They acknowledged that they were required to. They placed Mr. Coleman at 50% for 6 months, but did not satisfy the condition precedent for changing his disability rating from that point on.
Just about this language in the opening brief that says Coleman underwent an examination that is the functional equivalent of a temporary disability retired list re-examination on February 22, 2006. That date fits within the, it goes on to say that this is a quote from the brief itself, says it fits squarely within the reevaluation period. That seems to be a concession to me. But as I indicated, alluded on, I understand that the UNC students got a hold of this and you wrote the reply brief. You seem to have written around it without really dealing with that session.
Well, Your Honor, we think that the distinction between the functional equivalent and the legal equivalent is an extremely important one here.
How is it?
Well, the functional equivalent, we can see that it's the functional equivalent because were the Air Force to have conducted the examination, they would be using the same schedule, the same VA schedule for rating disabilities. They would be looking at the same evidence. And so we think in that way, it can be seen as the functional equivalent. However, it is not the legal equivalent as evidenced by 4.129, specifically requiring the rating agency to schedule the examination. The rating agency in this case is the Air Force. And so the VA examination under the plain reading of that regulation cannot count as the legal equivalent of the examination. I'd like to move on to a few points discussed by the government. And this truly goes to what we've been calling the 10 versus 30 argument, whether Mr. Coleman, when they were looking at his disability rating, whether 10 or 30 was the more appropriate rating. The government noted a bunch of symptoms. They looked at the PDBR report, noted a bunch of the 30% symptoms, and then basically refuted that evidence with old, stale evidence from outside the TDRL period. Furthermore, the government, from the PDBR report, noted Mr. Coleman's generally intact social and occupational functioning at a 30% rating. They also said that a 30% rating could be surmised looking at the evidence. All of that evidence, the generally intact social and occupational impairment, that is a 30% rating looking at 4.130, which is the schedule for what rating corresponds with what symptoms. And so the government themselves noted in the PDBR report symptoms consistent with a 30% rating. And we think that further underscores the arbitrarily and capricious nature of their decision. Your Honor, I'm out of time, so
All right. We appreciate the arguments of both counsel, and the court wants to express its appreciation to the students in the program for undertaking representation in this case. It serves a vital function for our system to operate, and we gratefully acknowledge it. So we will come down and greet counsel and then move on to our last case.
Good morning. May it please the court, Melissa Baldwin on behalf of the appellant Deontay Curry. We are asking the court to vacate the amended judgment and reinstate the $0 restitution award from the original judgment because the district court lacks statutory authority to modify that order. We are also asking this court to vacate the 120-month upward variance sentence as procedurally unreasonable because the district court relied on clearly erroneous factual findings.
But was that a final order on the court's part? Didn't the court leave that figure for restitution open to be determined at a later time?
No, the district court did not. In the original judgment, the district court issued a self-executing restitution order saying failing a restitution determination by November 9th, the amount automatically becomes $0 without further order of the court. Now that's a final judgment for purposes of appellate review and claim preclusion purposes, as the Second Circuit recognized in the Gonzalez case. There was nothing left.
But didn't the district court have the authority and the power to change the restitution amount if he or she were convinced based upon later evidence that it was incorrect or insufficient?
No, Your Honor. And so that's from the case law makes a distinction between deferring judgment until a later time and reopening restitution and changing the amount. And so that
wasn't the judge deferring to a later time, and after 90 days, the government offered them the amount at that, and then he set it down for a further hearing, did he not?
No, the court did not. I mean, the problem is that the original judgment imposed the restitution order became $0 as of 12:01 a.m. November 10th. And so at that point, the government's recourse was to seek appellate review in this court. The government didn't file a notice of appeal. So to the extent there is any errors or issues in that original judgment, that's not before this court under the Manrique and Greenlaw cases. So this court has to accept the fact the district court entered a $0 restitution order as of November 10th. And as a result, it required statutory authority to then reopen the restitution issue and amend it to $366,000.
When you proceed under statutory authority, that would be a good argument that there is a final order, but that final order is subject to change under the code section, which the court referenced when it's entered its order. So the quirky thing to me in this case is that the court had the language in the August order that said it'll be $0 on November the 9th, government files. And under what might have appeared to be a plain reading of the statute, that would be the end of it, and your argument would be correct. Seems to me that there are two difficulties with that. One is that there was notice that the government had filed this proffer of damages, and Mr. Curry was on notice that he had to respond by a particular time. I may have believed that he did not need to, for the reasons you've already listed, but nonetheless, he didn't. And then we consider the Dolan case and others that seem to have added language to the statute that others might have thought wasn't there. And so under Dolan and some other cases, it doesn't seem quite as clear that final is as final as you indicate.
Respectfully, Your Honor, I disagree. It is that clear. And first, on the idea that we had noticed, this court's decision in Rogers says to the contrary. It says when the claimed error on appeal arose at the time that a final judgment entered, the defendant can take an appeal without objecting in the district court and enjoy ordinary review. That's exactly what happened here. Our claim of error is there wasn't statutory authority to modify the restitution order, which only came into play when the amended judgment was issued. At that point, our notice of appeal clock began ticking. And so we had to file it to preserve our right to seek.
So your view is that even though Mr. Curry was on notice that was an invalid act?
Well, I would disagree that we had noticed it was invalid. I don't think there's anything invalid about a district court enforcing a 90-day statutory deadline. The Supreme Court said the district court.
No, that's not the point. The point is that Mr. Curry was on notice that the government had filed, and he was asked by the court to make whatever response to that he desired. He didn't.
Well, the notice that we're entitled to under Burns versus United States is notice that the district court was contemplating making a decision, not that the government was seeking to upset a final judgment in contravention of a mandatory claims process.
Right, but that, you could certainly believe that, and that could be your position. But why weren't you under an obligation to tell the court that?
Well, what would our response have been? Final judgment is entered. To the extent the United States of America feels it was wrong, it should seek appellate review. It shouldn't be on the onus of an indigent defendant to tell the United States of America to comply with the federal rules of appellate procedure.
But wasn't it clear from the record that this was not a final judgment with respect to the amount of restitution? Wasn't the record clear on that?
No, Your Honor. The judgment issued by the district court.
He didn't leave the door ajar to change it?
No, the district court's ruling, plain language, was failing a restitution determination by November 9, restitution becomes $0 without further order of the court. So by 12:01 a.m., November 10th, when a restitution determination was not made, final judgment entered.
And you're saying the court did not have the authority to change that? To
Yes,
revisit the issue of restitution, should it be clear later that there was a defined amount of restitution?
Correct, Your Honor, and that's backed up by this court's decision in Peligi, as well as the sister circuit decisions in Murray, the Fifth Circuit case, Bedoni, the 10th Circuit case. In fact, in Dolan, then Judge Gorsuch emphasized that the prior 10th Circuit decision where this came up remained good law, notwithstanding Dolan's exception for missing the 90-day deadline, because in that case, the district court had made a restitution determination of $4,000 some odd dollars. A couple of days later, after entering it, the court realized, I made a mistake. I can include lost wages. I'm going to reopen this and add those to the victim. The 10th Circuit said no. And that is in accord with.
But in that case, the judge made a decision as the restitution that would do what that he or she thought was appropriate in the record. In this case, the judge left it open and indicated it would be determined at a later time. He just merely extended the amount of time for determining the amount.
Again, Your Honor, I disagree. The district court made a determination, and that determination was $0. I am going to enforce the 90-day deadline Congress set in 3664 D5.
But he put in there to be TDP, to be decided, or T. Didn't he put in there initials?
Yes, but then he also put in the clarification
TBD.
of failing such a determination by November 9th, it becomes $0 without further order of the court.
Wasn't that just a message to the clerk as that's what should be put in the final record if no restitution was determined between then and later in the case?
No, Your Honor, and this can also be seen, the Fifth Circuit's decision in Murray, similarly, there wasn't a actual dollar amount entered. There, the district court found it was inapplicable under 3663 AC3 because of complexity issues. And there, when the district court said, actually, I can figure out restitution, again, the Fifth Circuit said, no, you need statutory authority to reopen and modify a restitution order you had entered, and none existed. And that is the situation we have here.
So walk through this and follow your line of argument. The court did reference a specific statute D5 there as the basis for which he's proceeding. Your contention is by including the $0, that was the end of it. At the 90-day period, Supreme Court has made clear that 90-day is not absolute, as long as you give some notice to it. And I don't know, to the extent we look to what the actual facts here, there's no question the victims in this situation would be entitled to a restitution. And it would seem that a district court judge who's in the position of Judge Conrad here would well understand that a restitution is something should be given. And when he gives initial order, he's expecting, at least by that date, that's what the law would do. If you don't do anything, then it'll be $0. Government does file something on that date, as I understand. Didn't they file a motion?
They filed a motion for an amount with any substantiation.
And so then for the court to then receive that motion it would seem to indicate, I mean, court does a lot of stuff, but if you want to get the benefit of zero, when it looks like manifestly there is some basis for a restitution here. And then he simply just says, you know, we move forward. Why is that not some notice to the defendant, at least in this instance, that the court is moving forward with this?
Because the only time the district court gave any indication it was actually contemplating granting this, untimely, unauthorized action was the day before it issued the amended judgment, which started our appellate clock ticking. And again, we had to file our notice of appeal or we would waive our ability for appellate review. And once a notice of appeal is filed, it would be divested of jurisdiction to the extent we even filed any motion for reconsideration.
Is it a real complaint that the defendant didn't get notice? Because that 90-day period is not exactly absolute. And so by giving him notice, what does that do for your case? I mean, you simply give notice and now you go ahead and proceed. So are you saying we simply just say, go and give him notice and remand for determination of restitution?
No, my position is the notice issue is what triggers Rogers an ordinary review. But the problem here is there was no statutory authorization to modify that amount. And now I'm running out of time and I would like to address.
Let's just assume for purposes of argument that we don't find that persuasive and the plain error review applies. What's your best argument in that case?
Sure. So the best argument in that case is we still prevail under that prong because it is, under the Olano standard, because it is black letter law, this court's decision in Davis, that a district court needs statutory authority to order restitution. So the $366,000 had to be statutorily authorized. The government has produced no case saying that a district court can modify or reopen the restitution determination in this case. It relies wholly on the fact.
Allow a court to modify.
Well, it does, Your Honor, but not in this context. That is for losses that were discovered after sentencing for which the district court found there was good cause to include.
Is there differentiation between new stuff that a victim may bring after something occurs that allow the modification as opposed to the initial determination of it?
Right, but we have an initial determination here. The fact of the $0 entry is what distinguishes this case from Dolan.
Nothing. He said by operation it would be zero, but was it really a determination? What was it? What evidence supported it? What evidence supported zero?
Well, the district court's within its discretion to enforce Congress's 90-day deadline. I mean, the Supreme Court in Dolan explicitly said Mr. Curry would have a right to seek a writ of mandamus from this court to compel compliance with the 90-day deadline. And furthermore, it makes sense why a district court would maybe perhaps do this because the 2255 clock won't start ticking in a deferred restitution case while the amount is outstanding.
But the judge did that because there was no information that he had at that time to determine what amount of restitution was due.
And the government was well on notice. They had 90 days to get him that information to make a decision. They didn't do it and they didn't appeal it. And so this $0 restitution amount is final for purposes and should be.
That assumes that the motion that the government filed, which was within the 90 days, is insufficient.
Well, based on the plain language of the judgment's order, failing such a determination, only the district court is entitled to make a determination of the restitution amount. The fact the government moves for a restitution determination.
But Dolan says it's got some pretty weaselly language in there about the 90 days doesn't bind even if it's the fault of the government. And that to me goes back to why the standard of review is pretty important, because I don't think Dolan and these other cases are quite as dogmatic as you represent.
Well, because I'm saying Dolan is inapplicable here because we have a restitution amount entered on a final judgment triggering the rules for modifying a restitution order. But I see I only have a very short amount of time and I'd like to address the prison sentence.
I want you to answer me regarding this. That is, I want to understand your position. That is, what if the judge had entered a zero?
I would not be making this argument.
Why is that?
Because it would be Joel.
Hear me out. What was zero based on? How did he get zero?
Zero was based on enforcing the 90-day deadline.
So if he didn't say zero, then you got a 90-day deadline.
If he
So
didn't
is
say
it zero? If it passes 90 days, does it just by law become zero?
No. It's because the district court made the affirmative ruling in the judgment that it would become zero without further order of the court
Based on
past the deadline.
what? Based on what? He had no evidence one way or the other, and he was saying he's anticipating there's nothing. But based on what? At the time he entered it, what did he have it based on? The zero.
He based it on Congress's determination in 3664 D5 that restitution determination should be made up to 90 days after the
Turn to my
sentencing hearing.
question. So if he doesn't say zero, based upon Congress determination, in every case where it's not done in 90 days and the court doesn't do anything, your position is it's zero.
My position is the district court absolutely has discretion to enforce the 90-day deadline Congress set in 3664 D5, which is what the district court did in this case when it issued its original judgment.
I don't think you and I are disagreeing in terms of what we're saying. I should be clear in what you're saying. You seem to be saying zero doesn't matter. It's 90 days is the big thing because Congress said it, and all the judge was doing was enforcing the 90 days, which is law. So even if the judge doesn't say it, because Congress said it, when 90 days pass, your position is zero. Is that correct?
It is the confluence of the two factors in this case, which is the 90-day deadline and the district court's affirmative ruling of the zero amount. Because Dolan does foreclose us from saying simply absent a determination by the 92nd day, the district court can't order it. It can. That's what the Supreme Court said against a vigorous dissent by Chief Justice Roberts. But here, because we have the initial determination, or excuse me, we have the determination of zero, that does make it different. And it does mean that the district court can do that and enforce the 90-day deadline.
Thank you. You've got some time left on rebuttal. Ms. Wood.
Morning, Your Honors. Julia Wood on behalf of the United States. May it please the court. The district court in this case did exactly what Dolan allowed it to do. It made clear at sentencing that it intended to make a reasoned decision about restitution and that it would order restitution. It was only leaving the restitution amount open for 90 days so that it could make that reasoned decision about the amount of restitution owed. It made that reasoned decision 118 days after sentencing.
So why did it include the, if I don't do it by this date, it's going to be zero? That seems to be the kind of oddball in this case.
It is, Your Honor, and we concede that that language is not a model of clarity. I believe to Judge Hudson's point, it could be a direction to the clerk. But in any case, in this,
it's a model of clarity as in what he said. What you it doesn't mean ultimately what he intended to do, which it stands to reason. But he did enter the zero there. And does the law require that any amount, even zero, it would seem to me something needs to support that. Either that you make a finding, but he hadn't made a finding on that by that date that there was nothing there. He's anticipating there's nothing there. And I think it's significant that the government didn't file something on that date, which indicates we want to present something, which you can extend to 90 days. I mean, the Supreme Court said you can, 90 days is not an absolute, in that if you can show there's some effort to bring it in. And so it seems to me that happened here. But the zero is pretty clear.
Zero is clear, but the zero is not a final judgment that imposes an order of restitution under the Mandatory Victim Restitution Act, because as Your Honor notes, it's not based on anything. It's not a reasoned determination of restitution. It didn't require Mr. Curry to pay restitution for the bodily injuries that he caused MC, for any of those injuries that the statute required him to pay restitution for. And therefore, that zero did not convert into a final judgment that imposes an order of restitution, because it wasn't an order of restitution under the statute.
What if the trial judge in this case had decided at the end of 90 days and says, okay, I said it was zero, it's over. You would probably be before us right now appealing. And what would be your argument that the trial court entered that zero on the 90th day, even though at that time you hadn't brought something to it, what would be your argument, but you didn't file this motion?
If we hadn't filed this
Because he
motion,
could have done that, couldn't he? I mean, given this order, it looked like to me, he could have had the discretion to say, I told you 0 and 0 is 0, and that's it. Would you be appealing that? And if so, what would be your argument?
if he had entered an amended judgment, and I will note that that language says, when the court makes such a determination, it will enter an amended judgment. If the court had entered an amended judgment ordering 0 on November 10th, then I think we might be in a different position and we might have been under a duty to appeal.
What if
that
he just
order.
done nothing? Says, no, that's the end of it. Not any more judgment. My judgment has already been entered. The 0 is there. And that's it. Nothing amended. I gave you that and it became effective on this date, the 9th day, and 0. Would you be appealing that? And what would be your argument?
If he had denied our motion?
Yes.
Yes. If he had denied our motion.
Denied it the same day. Just say, nope, you don't have anything by 5 o'clock. I'm going home and have dinner and it's over.
We would
And I know Judge Conrad wouldn't do it. So.
Right. We would have appealed that denial because we believe that that would conflict with the Mandatory Victim Restitution Act, which requires that people who are convicted of crimes causing injuries to their victims pay restitution. So I think
what
that
happens if we determine the August order is a final order of restitution, but subject to amendment under the modification under the statute, and then the final chronological order in this case recited that modification under subsection B5. What's wrong with that?
if this court were to find that the 0 became a final judgment imposing an order of restitution on November 10th, when the court didn't take any action, then I think that the courts could still hold that the district court was within its authority to modify that final order under 3664-0, which lays out the ways that a final order of restitution can be modified because 3664-D5 is listed under O. And I think the court would have the authority then to modify its 0 order.
Because at this time, until day 90, there wasn't any evidence of any amount.
There was evidence at sentencing that the victim had spent 21 days in the hospital, that she had incurred significant medical bills. The judge actually mentioned medical bills when he held restitution open. And I will note that we filed that restitution request on the 90th day because that's the day that we got the supporting documentation from the victims. Sometimes we do have difficulty getting information from victims who are dealing with many challenges, trauma. And so, you know, we make our best efforts, but I think that's why, specifically why Dolan held that even if it's the fault of the government or the court, victims are still entitled to their restitution.
Specifically, what did that motion ask for?
The government's motion?
Yes.
It asked for approximately just over $366,000.
But I mean, did it ask for an extension of the 90 days?
It did not, Your Honor. We filed our motion on the 90th day, which we, for better or worse, have viewed as kind of our deadline to try to get that information in.
Why didn't you, when you read that judge's order, which seems to be unusual? I don't think I've ever seen a judge do that. Got interested.
My guess is,
Yeah.
regardless of how this case comes out, you're not going to see a district judge do that again.
Yes, it is relatively new language in our district on this judgment, but we, you know, the best practice would have been to file to ask for an extension, and we do that now when we see this kind of language. But we thought, you know, we work with diligence to try to get these restitution requests in, and we just made the decision.
So do you think the trial judge actually construed your motion as one to extend that 90 days to allow you to do it?
He could have, you know, and because I think, you know, the district judge does have the authority to interpret his own judgments and to interpret our motion as a, you know, as a request to extend that time. We wouldn't have made the request if we didn't think that the district judge had the authority to grant our motion. After
So opposing counsel says that the fact that Mr. Curry made no response to the notice that your motion had been filed by the deadline for making a response, that's irrelevant. They're entitled to normal review and it's not plain error review. What do you say to that?
I don't think that's correct. And I think that's, council referred to the 90-day deadline as a claims processing rule. And Dolan explicitly held that it's not a claims processing rule. It's something even less. It's a deadline that's intended to prompt timely action. And we know Dolan and Manrique, which council raised, stated that a defendant loses the protection of even a mandatory claims processing deadline if it doesn't raise it. And so I think that applies even more strongly in the case of a deadline like this 90-day deadline, which we know is not a mandatory claims processing rule. It's a deadline that is intended to prompt action. And we know from Dolan that the court still retains the authority after that deadline to order restitution. I'd like to just also point out, I think we've talked a little about this, but that Mr. Curry's interpretation of this judgment language would also conflict with the court's oral pronouncement that it would order restitution and that it was holding it open only to make a reasoned decision. And in the case of a conflict, the court's oral pronouncement controls. And it would also conflict with the court's own interpretation of its order, which obviously the court believed that it retained that authority.
Did the judge put that on the record during the hearing?
There wasn't actually the sentencing hearing or the restitution?
Sentencing hearing.
Sentencing hearing. He did put it on the record that it is in the record on, I believe, page 55, that he intended to order restitution. He adopted the PSR, which said that the MVRA applied and restitution would be ordered. And he did say specifically he was holding it open to make a reasoned decision about medical bills.
Thank you.
Curry has identified no prejudice from the court's delay. As your honors have mentioned, I think Judge Wynn made this point. There's no dispute that the MVRA requires him to pay restitution, and there's really no dispute that his victim suffered grievous injuries, spent 21 days in the hospital, lost her spleen, pancreas.
So they could have brought a separate civil action, could they not? Just give restitution, even if it hadn't been ordered by the court in the criminal proceeding?
The victims could bring a civil action, but the Mandatory Victim Restitution Act also requires that the district court grant them the restitution.
Kind of a stretch to say he doesn't have any prejudice for it. He's got a $300,000 judgment against him. Amount of money. But I get your point. Ultimately, it could be that the big thing being whether he got the notice of it. And what would be the strongest evidence that he was given notice that would allow for an extension beyond 90 days?
His trial counsel received, we filed our motion through the court's ECF system, and his trial counsel does not dispute, his appellate counsel does not dispute that they received that notice of the electronic notification, which provides notice, and just say that they were simply unconcerned, and that's why they didn't raise an objection. But in this case where the district court had made clear that it intended to order restitution, they were still under an obligation to object if they disagreed with the restitution amount that we requested. And I think to your point, Judge Wynn, the proper standard for prejudice here is under Dolan. Dolan talked about prejudice in terms of losing evidence to rebut the amount of restitution. And here there's been no indication of any kind of prejudice in that manner.
Well, no prejudice in the sense that time prevented them from coming up with witnesses to rebut the evidence and that sort of thing. I think as Judge Wynn indicated, to go from 0 to 300,000 indicates some degree of prejudice. On the other hand, I assume your argument would be under plain error review. We never get that far down in the list.
That's right. That's right. We don't believe there's an error. And if there were an error, it would be far from clear based on the language of the judgment, Dolan and 3664-0 as well. I'd like to touch briefly on the sentencing issues in this case. We do not believe that the court relied on clearly erroneous facts when it upwardly varied to 120 months. The court mentioned issues related to childbearing. There was evidence in the record that MC and her fiance were working to have a baby.
I think your argument on the sentencing issue is well presented in briefs on both sides. Maybe the judges feel different about it.
That's fine.
If Your Honor, we are happy to rest on our briefs if Your Honors have no further questions.
I don't think we have any further questions on that part. Anything else you want to tell us?
I think that covers our arguments on the restitution issue. So we would ask that this court affirm the district court's judgment. Thank you.
All right. Ms. Baldwin, you've got some rebuttal time.
Thank you, Your Honors. So a couple points. First, the government is violating the cross appeal rule and asking this court to consider challenges to a judgment they failed to file a notice of appeal on in contravention of a mandatory claims processing rule. The mandatory claims processing rule I referred to is not 3664 D5. It's the requirement to file a notice of appeal if they disagreed with the $0 restitution order. And here they say, well, the $0 restitution order, the court can ignore because it's invalid. The MVRA requires a defendant to return, say, medical costs, and that didn't happen here. Well, that is no different than what happened in Green Law when Congress said you have to impose a 25-year mandatory minimum consecutive sentence. You don't get to say, I'd rather it be 10 years. The government had an obligation to appeal that. They did it. In fact, the government admitted, had the district court entered an amended judgment entering $0, they would have had an obligation to file a notice of appeal. But that is exactly what the district court did in the original judgment with its self-executing restitution order. And then
What happens if the judgment is in it and then there's nothing said about restitution? And then subsequently, the court then seeks to modify it to include restitution. Let's say there's no zero, there's no mention of it. You just enter the order, final judgment on the case. And then the court says, no, I want to modify this to include restitution. Can the court do that?
Within the 90 days.
Within
Let's
the
assume that.
So I believe it could, especially if restitution was mentioned at sentencing. I'm a little unsure if restitution just didn't appear in the PSR or sentencing or the judgment, and then 2 months later the court's like, actually, I think I can impose restitution. But if the district court, if restitution was mentioned at sentencing, there's nothing in the judgment one way or the other, I think then there would at least be a very strong argument that Dolan authorized the district court to enter the order.
Under the Victims Act there, those are the ones that are entitled to this. If a judge fails to, let's say just fails to do anything, do they have some means, even if it goes beyond 90 days, says, wait a minute, court, you should have entered restitution for me on this. Do they have something, or does that have to proceed to a civil action?
No, I mean, absolutely, Your Honor, in the sense that
What?
absolutely the victim does have a right. I think the government under the MVRA has a responsibility to litigate their rights under the MVRA. And even if the government fails that, the victims also are entitled to seek a writ of mandamus, which has been done in other cases.
Here you have victims who ostensibly are entitled to $300,000+. And I mean, what happens if the government just didn't do its job on the prosecution side to put it in? Can they intervene, or how do they say, wait a minute, you didn't consider that I'm entitled to restitution under this act, which requires you to do it? How do they enforce that beyond 90 days? Or can they?
So there is a provision in the code. I don't believe I have the site for me. I can give it to you in a 28J letter, but Congress gave them certain rights. And one of the rights was actually.
I'm just saying, what I'm getting at is, what if you are right, that you get a zero, but don't they still have an entitlement to $300,000? How do they come now and says, wait a minute, something's wrong here. The judge did this, the prosecutor didn't do their job, but the act says I'm entitled to it. How do you then force the court? Is that a mandamus to come up to us and to go back and say, go back and comply with the act and give these people restitution?
Well, I think
in other words, does mandamus exist for someone who's, I guess, brought in as a party under the act? Could they then seek a mandamus to us to say, to instruct the government to go back and determine the amount of restitution for them?
I believe they could if they followed whatever, procedural or appellate rules are.
So even if you win, they could still do that today.
I'm not sure they could, because I'm not sure time.
They would have zero.
They have a notice.
They're entitled to something, and the act says they're entitled to it. Why couldn't they can't go back? That court and says, look here, somebody messed up here and you got a zero, but I'm entitled to something. How do I get it?
Well, so, there are other provisions in the United States Code apart from the MVRA, which provide for restitution. So for example, 18 USC 3663 authorizes restitution. And you know, so the victim was horribly injured, and we understand that she was in the hospital. But also, you know, Mr. Curry is now subject to a $300,000 restitution order, which he could actually go back to prison for another decade for not paying. And he never even had an opportunity to object to it because the government didn't comply with filing a notice of appeal, a very basic requirement.
You understand that what you're saying. You're saying Mr. Curry now may have to pay this $300,000 because he didn't have an opportunity to object. So you just asking us to send it back, giving an opportunity to object and present evidence?
That was my alternative, but I think, again, there is no statutory authority to modify the $0 restitution order. And so our position is necessarily that that is foreclosed.
The statutory authority for these people to get money. And somebody along the way, under your interpretation, dropped the ball. So they're entitled to it. You say your problem is he didn't get a chance to object. Why not just send it back and say, Judge, give him a chance to object and present whatever he wants to present on it, and then enter an order as you see appropriate.
Because I'm not even sure the court has jurisdiction to do that, because our whole argument rests on the fact that $0 is a final judgment that was entered and that wasn't appealed. So this court, you know, can reinstate that, can vacate the amended judgment and reinstate it, but we don't think there is any basis to undo that final judgment rule and basically issue restitution anew. A restitution determination was made to the extent that there is, you know, a mechanism still available to provide these victims with restitution. That's, you know, on the government to present in an orderly fashion that we can respond to.
All right.
With that
Thank
said,
you. Thank you very much.
thank you for your time.
We will ask the clerk to adjourn court sine die, and we'll come down and greet counsel.
This honorable court stands adjourned sine die. God save the United States and this honorable court.